Good morning, everyone. I want to welcome everyone to this morning's meeting of the Interim Committee on Legislative Operations and Elections. I believe we have all members present, but for one, and that member's running a little bit late. So, Madam Clerk, if you'd please call the roll.
Senator Daly?
Here.
Senator Severs-Gansard?
Here.
Assemblywoman Dickman?
Here.
Assemblywoman Gonzalez? Assemblyman Hibbets?
I'm here.
Assemblywoman Miller?
Here.
Assemblywoman Mosca?
Here.
Chair Orenshaw?
Present. And Madam Clerk, please mark Assemblywoman Gonzalez present as soon as she arrives. Before we begin, I would like to make several housekeeping announcements. Members who are joining us virtually, please be sure to keep your video on so that we know we have a quorum. Please also be sure to mute your microphone when you are not speaking to minimize background noise. Agenda items may be taken in a different order than listed. 2 or more agenda items may be combined for consideration. An item may be removed from this agenda, or discussion of an item on this agenda may be delayed at any time. Meeting materials can be accessed on our committee's webpage, located on the Nevada Legislature's website. You can also sign up for electronic notifications related to our committee's activities on the Nevada Legislature's website. We will have a public comment period at the beginning and at the end of our meeting. We are limiting public comment to 2 minutes per speaker. Members of the public may also provide testimony in other ways in addition to public comment, and those ways are listed on the agenda. To call in for public comment, please dial the following phone number, 888-475-4499. Again, that phone number is 888-475-4499. When prompted for the meeting ID, please enter the following meeting ID, 845-8785-4029, then press the pound sign. Again, that meeting ID is 845-8785-4029. Then you need to press the pound sign to be able to log in and on the phone and make public comment. If you would like to provide written comments, you can submit them electronically through email to the following email address, Interim, and the LOE and the capital and the I are capitalized, and the rest of it, Interim, is small, lowercase, at lcb.state.nv.us. Again, that email address is LOE Interim, and the L, the O, the E, and the I are capitalized. Everything else is lowercase. At lcb.state.nv.us. You can also mail them via old-fashioned mail to 401 South Carson Street, care of the LCB Research Division. Again, 401 South Carson Street, Carson City, Nevada, 89701. And last but not least, you can fax comments, written comments, to the following fax number for the Nevada Legislature, 775-684-6400. Again, that fax number for the Nevada Legislature, and we will receive it for our committee, is 775-684-6400. Please make sure that you on your written comments that you do mention that it's for the Interim Committee on Legislative Operations and Elections. I do want to remind members to silence your electronic devices, especially cell phones and laptops, during the meeting. With that, we will now move to our first session of public comment. Here in Carson City, is there anyone who wishes to make public comment? And I'm not seeing anyone up here in Carson City. Down at the Sawyer Building, is there anyone who wishes to make public comment? I'm not seeing anyone come forward down in Las Vegas. So broadcasting, is there anyone on the phone lines who wishes to make public comment?
Thank you, Chair. If you would like to provide public comment, please press *9 now to take your place in the queue.
Good morning, Oscar Williams here, OSCAR-WILLIAMS. I am a little concerned about chain of custody in regards to, I'm in Washoe County in Reno, and we have the largest homeless shelter in the nation here called the CARES Campus. The CARES Campus has a mail center, and the chain of custody of mail ballots through that mail center is not clear, and I hope that Carrie Ann Burgess will address my concerns in her presentation. Who is managing the mail center? How is mail secured for individuals? Who has access to that mailbox, however that mail is held for people. How long is the mail held until it's proven non-deliverable? And then what happens to the mail? Does it get thrown away? Are mail ballots sequestered and returned to the register of voters? And so those are some of my just general concerns that I have about the mail office at the CARES campus and issues of chain of custody. Thank you very much.
Thank you, Mr. Williams. Broadcasting, is there anyone else on the phone lines who wishes to make public comment?
Yes, Chair, one moment.
Good morning. My name is Ellen Gifford, and I'm speaking on behalf of fellow citizens who have voiced their concern about voters who are uninformed about SB 406 being put into law. Section 1, subsections 1 through 6 of this law addresses the possibility of a Category E felony being committed by anyone who would use or threaten, attempt to use any force, intimidation, coercion, violence, restraint, or undue influence with the intent to A, interfere with the performance of the duties of any elections official relating to elections, or B, retaliate against any election official for performing duties relating to an election. One might think that Nevada's legislators were convinced that such a law was necessary because there was a history of such activities. This is a question that is in the process of being addressed. Nonetheless, it is imperative that prior to June's elections, the public be made aware of this new law. Since the law is not yet codified in Nevada's statutes, its contents are not readily available. It should therefore be the responsibility of Nevada's Secretary of State to communicate this information. We would appreciate a response from the Secretary of State about how this will be accomplished. Thank you.
Thank you, Ms. Gifford. Broadcasting, is there anyone else on the phone lines who wishes to make public comment?
Chair, there are no other callers choosing to participate at this time.
Thank you. And members, I think I'm going to give it just another minute in case anybody was still trying to call in and just got the number. So if we'll just wait another minute, give someone else a chance to call in. Broadcasting, I just wanted to check. Has anyone else called in who wants to make public comment?
The public line is open and working, but no other callers have joined.
Thank you very much. Okay, members, we will now move to agenda item number 3, approval of the minutes of the meeting on March 22nd, 2024. All members should have been emailed the draft minutes, which were provided in advance of the meeting and posted on our committee's website. Committee members, are there any questions about the minutes? Anything that members feel needs to be changed or corrected? I open it up if any members want to be heard. If not, I will entertain a motion to approve the minutes of the meeting of the March 22nd Interim Committee on Legislative Operations and Elections.
Motion to approve the minutes from March 22nd.
I have a motion from Senator Daley. Is there a second? Second from Vice Chair Mosca. Any discussion on the motion? Not seeing any hands for our members who are on virtually or down at Sawyer Building, but if I missed you, please don't hesitate to jump in, and because I don't want to miss any members who want to be recognized. But I don't see anybody. So with that, all those in favor, please say aye. Aye.
Aye.
Aye.
Any opposed? Madam Clerk, please note that that motion passed unanimously. We will now move on to agenda item number 4. We have a presentation on voting for unhoused persons and other individuals with non-traditional addresses. And we're very fortunate to have with us Mark Volashin, Deputy Secretary of State for Elections, Nevada Secretary of State's Office, Lorena Portillo, our Clark County Registrar of Voters. They're both down at the Sawyer Building in Las Vegas. And then here in Carson City, we have Carrie Ann Burgess, our Washoe County Interim Registrar of Voters. Thank you all for joining us today.
Thank you, Chair. Good morning, committee. My name is Mark Volashin. I'm the Deputy Secretary of State for Elections, for the record. Our presentation today, I will start with a brief intro and discussion about the statutory requirements relating to this topic of unhoused individuals and those with unconventional addresses. And then I'll turn it over to my colleagues down here in Clark County before moving up to Carson City for the interim registrar in Washoe to provide some testimony as well. In quick summary, again, when we talk about voting with unhoused individuals and those with unconventional addresses, really we're talking about two specific statutes that govern this process. NRS 293.486 and NRS 293.5057. Starting first with 293.486, this statute, while fairly brief, originally created in 2001, really is intended to help and identify individuals who, again, are eligible, otherwise qualified electors, meaning that they're 18, a U.S. citizen, and have lived in the county for 30 days in the precinct for 10, but who otherwise have unconventional addresses. In many cases, we see this in rural counties, where, again, if you've lived in a very rural environment, your address may be best described by down past the big tree and across the two creeks, those sorts of locations. The intent behind this statute is so that the election official in the counties are able to identify the specific location of where that individual is at for precincting purposes. Additionally, it does support voting by unhoused individuals. And to be clear, we're talking roughly about 7,500 individuals as being identified as unhoused across our state per night. Again, this does not, the statute very clearly states this in subsection 3, does not authorize a person to register or pre-register who's not otherwise eligible. And that is an incredibly important point to highlight. When we talk about voting and the right to vote under the U.S. Constitution and the rights afforded to voters here in our state, this does not create a loophole or a gap. You still have to be an American citizen and again, meet the other requirements identified in our Constitution, State Constitution, and NRS 293.485. The other statute, NRS 293.5057, is a little bit more unique in that it only applies to presidential elections. This statute specifically allows individuals to vote for president and vice president during those specific elections. Oftentimes we see this one being used and referenced by individuals who travel across the country or live in an RV while they enjoy the beautiful benefits that our state has to offer. They are required under this statute to file a sworn statement with the county election officials, clarifying that they are not registered in any other state. And then it also they have to provide evidence of one, domicile in the state in accordance with NRS 41.191, two, that they have to maintain an account at a financial institution located in the state, or 3, that his or her motor vehicle is registered in the state. That being said, I will now turn it over to Registrar Portillo for the additional details.
Thank you very much.
you.
Good morning.
Good morning, Chair, fellow committee members. I'm Lorena Portillo, Clark County Registrar of Voters. I would like to briefly present information and statistics on the processes for registering individuals that identify themselves as unhoused in Clark County, Nevada. It is important to note that our voter registration form does not identify an individual as unhoused at this moment. So the way we identify is having record of the actual shelter or the four corners of the area in which the voter often resides. And that usually allows us to identify the precinct in which this individual would reside in, and we could offer them a ballot if they register and vote. According to local government estimates, at any given night, there are more than 6,000 people that are considered unhoused in Southern Nevada. In 2022 election cycle, there were approximately 2,000 registered voters, and of those, 156 voted. Currently, we have approximately 3,400 that are active registered voters. The registration process is not entirely different than that of a voter that has a defined residential address, except in the example when a voter provides 4 street corners where they often reside. We send their election materials to the nearest post office with a general delivery address according to their zip code, where the voter can pick up their election materials if they don't have a shelter address. That's really important to note as well. During the same-day registration period, the new voter must provide an ID, and if the address has changed, in this case, if the voter has become unhoused, we have an unhoused homeless affirmation that captures either the street corners or the address of the shelter in order for us to proceed to register the individual, and they can vote then and there at the polls. We want to make sure all the voting, actual in-person mail ballot voting methods are available to folks that have a defined residential address, but those that don't as well. So we want to make sure folks understand that they can too register and vote, and we are here to help them. We are here to help them understand, how we handle their registration and when they can vote, when are the deadlines. So we take this very, very seriously. Thanks to this conversation, we are thanking Heather Kellum, which is our registration supervisor, to produce a brochure in order to start working with advocacy groups. I just started that conversation not too long ago because maybe they don't understand that they could also participate, and they can, and they need to become prepared for the next election as well. They need to understand the important dates that's coming up as well. So we want to make sure to provide that soon. And they need to be able to exercise their right to vote as well. And with that, I'm here to answer any questions that you may have. Thank you.
Thank you very much, Registrar Portillo. I think before we go to questions, members, if we could come back up to Carson City, we have our Registrar Burgess from Washoe County. So please go ahead, and then I'll open it up for questions.
Good morning, Chair and committee members. I appreciate the opportunity to come and talk to you today. I am Carrie Ann Burgess, and I'm the Interim Registrar of Voters for Washoe County. I'm here to talk about the homeless community and how we are able to support them as they are part of our community, and we want to make sure that they know and understand that they are a vital part. What Ms. Portello had already talked about, I'm not going to reiterate because we do the same processes in both of our counties. So we have up here what's called a CARES campus. A lot of our unhoused use that address for their voter registration. Mr. Williams asked a quick question on this morning, an opening comment, and I'm going to answer a couple of those questions in this presentation. One is when they use that address, they are able to use it. They go pick up their ballots. They are able to use their ID in order to pick up their ballots. If they do not, and they are there the day after the election, they are actually brought to our office, and then we scan them in, and they are put in as undeliverable. For those that use it, the CARES campus, it makes it easy for them to get access to it, but those that do not, just like Registrar Portillo, we also use the cross streets. And then we deliver it to the closest post office. We do have field registrars that go out to our unhomed camps and to our other shelters that go and help register them if they would like. But again, same thing, they have to be residents of Nevada, be able to vote, and have an ID. In 2022 general election, we registered 382 who were considered unhoused, and of those, we had 38 who were verified and actually voted. In the 2024 presidential preference primary, we had 402 registered to vote, and of those, we had 12 that were able and willing and did vote. As the Registrar of Voters in Washoe County, I want to make sure that everyone who is eligible can vote. Just like Ms. Portello, we take this very seriously. We make sure that anybody who can and is eligible is able to vote. We do have other classes that we have field registrars. They come into our office, they're trained, and then they can go out and register them. We do have those classes, and that is another thing that we take great pride in, is that we look at those communities, because being able to vote, it gives them a sense of pride and a sense of community involvement. So, thank you.
Thank you very much, Registrar Burgess. Thanks for your presentation. And I believe there's another speaker down in Las Vegas. I didn't mean to miss you if you want to speak as well. Or so I'm so sorry about that. Please state your name for the record, and if you wish to make any comment, please go ahead.
Hi, my name is Heather Kellum. I'm the supervisor for the registration division in Clark County. So I'm just here if you have any questions.
Thank you very much, Ms. Kelm. Thank you for being here. And I do believe we have questions from members. I will start at the Sawyer Building with Assemblywoman Miller. And then members, if you have questions, please let me know. But if I don't see you, please don't hesitate to just jump in.
Thank you, Chair. So my question, I just want a little more clarification on the individuals that we're speaking about specifically. First, is it correct to assume that if someone has already registered before they are in a situation of being unhoused or traveling, that none of this applies to them because they're already registered? So they could literally just walk in and vote at any time. Would that be correct?
Thank you, Assemblywoman, for the question. Mark Voloshin, for the record. That is correct.
Thank you. So with that then, and I'm glad to hear that we can use shelter addresses to register. I know some states do allow that, so I'm glad to hear that. But going back to the situation between someone who is unhoused and that we can interpret as a more extreme situation, living on the streets, and then someone who is unhoused because they're traveling, they're just driving all over the country. This is what they're doing, right? And we're talking about registering, and we're talking about specifically for the presidential, those individuals in an RV, and Mr. Voloshin, you said, Deputy Director, I'm sorry, you said that they would sign an affidavit saying they're not registered anywhere in another state. So they're not from Maine and just now in Nevada today and want to vote. These would be individuals who are not registered anywhere. And then at that point, is it they're only voting for the presidential because that's the national election and not the state and local candidates?
I think you have a question, Assemblywoman Mark Voloshin, for the record. More or less, that's close, but and I apologize for the lack of clarity. So they have to still be otherwise qualified to vote in Nevada, and that's, I think, speaks to part of the requirement about maintaining an account at a financial institution or having a vehicle that's registered here. Those otherwise the requirements, so that if they are snowbirds driving around, again, that there need to be ties here, and that's specifically why the statute allows for that opportunity. Does that answer your question?
Yes, it does. Thank you for that. Yes, that absolutely does. I just really wanted to get the clarification, because in the other situations of being unhoused, and I'm sorry, Chair, follow up, please.
No, please go ahead. Please go ahead, Assemblywoman Miller, and then I have Assemblyman Hibbets after Assemblywoman Miller.
Thank you. So in the other situations of being unhoused, as long as an individual has a permanent address they could use, it would be fine, regardless of what their actual, literal, physical situation is on a nightly basis. Is that correct? Because I know unhoused is a broad definition.
Lorena Portillo, Clark County Registrar of Voters. Thank you for the question. It's good to differentiate the folks that, are driving around in an RV, but their home base is here, specific to Clark County. They do have to have an address that identifies them as this is their home base, whether that be a bank statement or other government-issued document. That is a difference, and they have a reduced ballot. Whereas a unhoused individual, whether they have the 4th Street corners or the shelter address, they get a full ballot and they're able to vote as, whether they have an undefined residential address, they do have an assigned precinct and they will get a full ballot.
Perfect. Thank you for that. I think that's the part that I missed during the presentation. We're talking about Nevadans who are touring around everywhere. Nevadans. Okay, thank you so much for that.
Thank you, Assemblywoman Miller. Thank you, Registrar Portillo. And that answers your question, Assemblywoman Miller. You don't have any other follow-up? Because feel free if you do.
No, that totally answers it. Thank you, Chair.
Thank you. Assemblyman Hibbets.
Thank you, Chair. My question is a bit of a technical question on the registering of an unhoused individual that uses the 4 corners method. Assuming that more than 2 or more precincts abut that particular intersection, how is the person assigned to a precinct?
Lorena Portillo, Clark County Registrar of Voters. And this is why we ask, it's a great question, thank you. We want to make sure it's not just 2 corners, it's the 4 corners that make up that block. And that's the way we can precinct. That's the only way we can precinct. So we do require those 4 corners in order to be able to precinct and assign a ballot. So for example, when an individual, a voter that hasn't registered, goes to the polls and wants to register to vote, they do, when we do the same day registration process. When the team leader is processing the individual, they have to call in to our office to ensure they receive the proper precinct. So the folks that we have a team lead hotline and we look up the map. We have a specific map in our voter database that assigns the precinct. And that's why we need those 4 corners. I hope that answers your question.
Any follow-up, Assemblyman Hibbets? Please go ahead if you do.
It answers it for the most part. However, is the person that is registering the unhoused person going to ask, okay, which corner of the intersection are you on, northeast, southwest, and assign them the precinct that way? Or are they just randomly assigning, they'll go into this precinct because it's actually at that 4 corners?
Lorena Portillo, Clark County Registrar of Voters. As the conversation is transpiring, we do want to make sure the corners are being identified as we talk about, where exactly the voter often resides. And usually it's not an issue because we're able to map as we're talking to our team lead hotline representative, where the actual 4 corners are. So if they give us 2, we ask them, okay, these are the other 2, and they oftentimes say, yes, this is the other one, but I don't know what this one, but we could identify according to the map that we see on our screen. I hope that helps.
Yes, thank you very much.
Thank you.
I appreciate it, Chair. No further follow-up.
Thank you very much, Assemblyman. Thank you, Registrar Portillo. Members here in Carson City or on Zoom, any questions? I have one question for either Ms. Callum or Registrar Portillo. I think you mentioned that of the 70 or about 6,000 unhoused eligible voters in Clark County, 3,400 are active registered voters. Do you have any data as to how many in recent elections have been able to actually participate and vote? And if you don't have that now, maybe could you provide it to us at a later date? Thanks.
Lorena Portillo, Clark County Registrar of Voters. Yes, thank you for the question. I do have 2022 election cycle numbers, which is registered voters was a little over 2,000, and 156 actually voted in that election of those over 2,000 registered voters. Currently, we have a little over 3,400 registered voters that either has an address at shelter or an address that has the four corners. That's the only way for us to identify anyone that can be considered as unhoused. Otherwise, we would need a field on our voter registration application because we have folks that are living with, a friend or a neighbor or, a family member that not necessarily is their home, but they're using that home as their residential address at the time. I hope that answers your question.
Yes, thank you very much for that data, and I appreciate
you.
everything our registrars are doing at the local level to try to make sure that, notwithstanding this traumatic time in people's lives, while they try to get back on their feet, people could still try to participate in our democratic institutions. So unless there are any other questions, I will I'll close that agenda item, and thank you very much to our Deputy Secretary of State for Elections, Mark Woloshyn, Registrar Lorena Portillo from Clark County, Ms. Callum from Clark County Election Department, and Registrar Burgess, Washoe County. Thank you very much for presenting today. We are now going to move on to agenda item number 5. We have a presentation on strategies for increasing public participation in the legislative process, including the use of social media by state legislatures. And we are very lucky to have Marie Henderson, Senior Policy Specialist, NCSL Center for Legislative Strengthening. She's joining us on Zoom. And really a timely agenda item, and I want to thank our LCB for looking at it, and thank NCSL for helping us with this issue as we try to get younger people who are more involved with social media active in the legislative process.
Good morning, Mr. Chair and members of the committee, and thank you for having us here today. My name is Mari Henderson, and I'm a Senior Policy Specialist with the Center for Legislative Strengthening at the National Conference of State Legislatures, or NCSL. First, a little overview of who we are. NCSL is the national bipartisan organization serving all state legislators and legislative staff. Our mission is to strengthen the institution of the legislatures, provide connections between the states, and serve as the voice of state legislatures in the federal government. NCSL provides unbiased and comprehensive information to help legislators navigate complex policy issues. As a member of NCSL's Center for Legislative Strengthening, I offer expertise on legislative rules and procedures and how they guide the work of legislative institutions. Today, we'll be talking about the public and the legislative process and how changes to legislative procedure can affect public participation. I'll be touching on 3 major themes today: changes in public participation in the last few years, a few procedural tactics used in other state legislatures to encourage public participation, and social media in a legislative environment and policies to consider thereon. It's safe to say that the COVID-19 pandemic changed how legislatures operated.
Ms. Henderson, I am so sorry to interrupt you.
Yes.
I think
No worries.
If we would just take a 1-minute recess. I think we might be having a technical issue with our live stream. So if you could hold on 1 sec, and I'm just going to take a 1-minute recess.
Absolutely. Thank you.
I will call the meeting back to order. I think we've resolved what we thought was a technical difficulty. If anyone's having trouble with the live stream, actually, I think I'll turn it over to our committee policy analyst, Ms. Pearl, just to explain where the live stream is on the legislature's website, if that's okay. And because we thought we had a technical difficulty, but I think it is working. I just want to make sure nobody's not able to access the live stream.
Chair? They
Assemblywoman
just
Miller.
came out. Yes, thank you. Staff just came out of the room and said they're still working on it.
Members will be.
So I'm not sure.
We'll be at ease then.
Okay, now, with the thumbs up? She just gave me the thumbs up.
That the matter is resolved, Assemblywoman Miller, or that we're still having a technical difficulty?
I don't know, she just, let me go clarify. She gave me the thumbs up. So I took that to mean,
We're getting, thank you very much. We're getting the message that the technical difficulty seems to be resolved. Thank you so much for keeping an
Yes,
eye on that, Assemblywoman. With that, we will come back to order. And Ms. Henderson, I apologize. Do you mind starting from the beginning on your presentation? Thank you for being so generous with your time.
Absolutely. Thank you, Mr. Chair. No problem. This is basically what we're talking about here today, technical difficulties in public access and making sure that the public has access. So I appreciate being able to see it in action. I'll just start from the beginning. No problem at all. Thank you so much for recognizing me and members of the committee for having us here today. My name is Mari Henderson, and I am a senior policy specialist with the Center for Legislative Strengthening at the National Conference of State Legislatures, or NCSL. First, a little overview of who we are. NCSL is the national bipartisan organization serving all state legislators and legislative staff. Our mission is to strengthen the legislative institution and provide connections between the states and serve as the voice of state legislatures in the federal government. NCSL provides unbiased and comprehensive information to help legislators navigate complex policy issues. As a member of NCSL's Center for Legislative Strengthening, I offer expertise on legislative rules and procedures and how they guide the work of the legislative institutions. Today, we'll be talking about the public and the legislative process and how changes to legislative procedure can affect public participation. I'll be touching on a few major themes today: changes in public participation over the last few years, a few procedural tactics used in other legislatures to encourage public participation, and social media in a legislative environment and policies to consider. It's safe to say that the COVID-19 pandemic changed how legislatures operated. In November of 2020, at least 32 capitals were completely closed to the public, with 37 also suspending guided tours. Many capitals also limited access to members of the press and even members of the legislature and staff. The pandemic changed how chambers operated as well. We saw adoption of new rules to allow members to attend or vote remotely, innovations to allow chambers to meet and vote in person while following social distancing guidelines, and changes to remote staffing procedures. With capitals often nicknamed the People's House, public access became intrinsically tied to how chambers handled procedure during the pandemic. Most relevant to the work of this committee, the pandemic spurred a massive shift in how legislators engaged the public in two major ways: remote testimony and streaming of legislative procedure. Prior to the pandemic, Nevada was one of the few states where some version of remote testimony was possible. For the most part, if members of the public wanted to participate in the legislative process, whether that be testifying in committee or by watching proceedings, they were required to travel to the Capitol. The implementation of policies, technological capacity, and rules to responsibly allow members of the public to participate from their homes or locations outside of Capitol buildings was a huge lift, but did change how chambers brought the public into the legislative process, even in places like Nevada or Colorado, where there was an existing mechanism for it. For many chambers, this access proved so fruitful that they adopted legislative rules to allow members of the public to continue to testify remotely, including clearly here in the Nevada Legislature. Another major change to public access was live streaming floor and committee proceedings. Limitations regarding who could be in the Capitol building also led to every single legislature adopting some form of live streaming in their proceedings for the first time. Anecdotally, we've heard from members and staff that the ability of the public to see what is happening in their capital from the comfort of their own homes has increased public participation in the legislative process. So, keeping in mind how drastically public participation has shifted in the past 3 to 4 years, what are some tactics legislatures can take to engage the public even more? We like to employ an old adage at NCSL. If you've seen one legislature, then you've seen one legislature. While each of our country's state lawmaking bodies have similar structures, powers, functions, and responsibilities, they're diverse and distinct in their operations and traditions. All of this to say, what works in one chamber may not work in another. However, there are some strategies in place in other legislatures that may be instructive. First, notice of public hearings. In this section, you'll hear me use the terms committee meeting and public hearing interchangeably. Legislative definitions vary across the nation and even between chambers. So by using both terms, I'm being inclusive of committee proceedings where public comment is taken and those where it is not. Nevada Assembly Rule 52.5 requires committees to provide, quote, adequate notice of public hearings on bills, resolutions, or other topics which are to come before the committee, end quote. Notices must include time, date, place, and agenda to be covered, and must be posted in the legislative building and online. Nevada Senate Rule 92 uses nearly identical language. This is in line with rules from other chambers, though there are a few nuances that we can see across the country. First, many chambers define the time frame of notice a committee must give to the public prior to meeting or soliciting public comment. The time frames vary a lot, ranging anywhere from 18 hours notice to 7 full calendar days. And second, as with all rules, there are 2 ways to flex notice requirements. Many chambers allow for the notice window to be shortened if there is an emergency, while some simply do not define how long what notice actually means, how long that actually is. These exceptions are especially common in session-limited states near the end of session. Once the public knows when the meeting is and what it's about, they are often required to sign up to testify. In most chambers, this is a requirement purely to make committee meetings run more smoothly. Having a list of who plans to testify makes life a little easier for the chair or staff. Access to remote testimony has changed this process in many legislatures. Previously, chambers often had pen and paper sign-up sheets outside a committee room, which is relatively straightforward, whereas now most registrations are digital. Ensuring that members of the public are aware of how to register lowers the barrier to entry. Significant, clear instructions at the site of registration can help make the process easier for members of the public that are unfamiliar with testifying. Which brings us to the final tactic, how to testify sheet. One of the handouts I provided was a compilation of examples of these kinds of documents put together by NCSL in 2020. Many chambers, including the Nevada Legislature, have sheets like this that instruct an interested party how to provide testimony to a legislative committee. The point of this handout, as we've heard from our members, is really about addressing the intimidation factor of speaking to a committee, which is very real. This is my job, and even I find it intimidating. So similar to ensuring the process of signing up to testify, clear indications on what it means to testify are important. You'll notice on the handout that this can include instruction on what to expect procedurally, time limits that may be enforced, the difference between a public hearing and a committee meeting, how to address the chair, and even decorum rules. I'm going to make a slight pivot to share some information with you about state legislative social media policies on behalf of my colleague, Mick Bullock. As I mentioned earlier, legislatures are all just a little different in how they operate. Social media pages are no exception. Using the link in the PowerPoint, you can access a compilation of every chamber's social media pages. Here is where you'll notice a visual representation of how social media accounts can be managed, either by the caucus or by a centralized office. For example, the Georgia House has an official Twitter page run by House Media Services, while Washington's official social media is tied to caucuses and run through caucus communications teams. Understanding how chambers manage their social media is key to understanding how a social media policy can best be constructed. There are 2 main things to consider when creating a social media policy: public records laws and who is covered under those, and if the social media accounts are official. Also called sunshine laws, FOIA, or open records laws, public records laws were intended to create a greater transparency between elected officials or public agencies and citizens. Since the Federal Freedom of Information Act passed in 1967, each state has since established its own public records laws that define how government documents are recorded and shared with the public. This means that anyone from the public, including members of the media, could request access to government documents such as emails, visitor logs, phone records, travel records, etc. Most legislatures are subject to the same public records laws that also apply to other government agencies. It's important to be familiar with your state's public records laws so you know how to properly dispose, retain, or disclose documents, such as redacting sensitive information, upon open records requests. Non-compliance or violation of an open records law may result in criminal or civil penalties depending on the state. Some practical advice often shared is do not put in writing what you do not want to see in headlines, and that includes your social media. Defining what accounts are official is incredibly important, as illustrated by a recent Supreme Court case involving an online interaction between James Freed, a city manager in Michigan, and a constituent named Kevin Lindke. The city manager had a Facebook account that he used for both personal and job-related purposes. The citizen made comments on the city manager's Facebook page that were later deleted by the city manager. The city manager also blocked the constituent. The constituent sued the city manager, alleging that his free speech was violated because a public official had deleted his comments and blocked him. In their decision, the Supreme Court established a two-part test to determine when a public official's conduct on social media amounts to state action. One, if he or she had actual authority to speak on behalf of the state on a particular manner, and two, if he or she purported to exercise that authority in the relevant post. Designating an official versus a personal account helps to ease some of the concerns touched upon in the Freed versus Lindke case. Public officials may consider designating a separate political campaign account to avoid potential conflicts or perceptions of impropriety. For example, what is shared on your political campaign account may not be appropriate to share on your official account. If a legislature has official accounts associated with it, it's very, very important to have a social media policy. A legislature-wide or chamber-wide social media policy creates a uniform guideline that all members and staff can abide by. The policy may include guidelines on how to not use personal social media account for official legislative purposes, how members can or cannot interact with the public, including blocking or deleting comments. It may note that there is no obligation that your official account needs to be open to comments or engagements with the public. But if you do allow public engagement, you cannot delete the comments, restrict access, or block anyone. And it can also give guidelines on how to utilize legislative staff in managing your social media account, because staff should not be managing your personal account or campaign account. You'll see some examples of social media policies in the second handout provided. We're currently working to update this document as well, so we're happy to send that along when it is done if you'd like it. Thank you again, Mr. Chair and the committee, for having me here today. That concludes my comments, and I would be happy to take questions at this time.
Thank you very much for the presentation, Ms. Henderson. And yes, when you do have that other document completed, that would be great if you could share it with the committee. Members, any questions? I'll start down at the Sawyer Building for Ms. Henderson. Down in Las Vegas. I can't see you, so if any members want to be recognized, please just feel free to jump in. Okay, not seeing anybody down at the Sawyer Building. On Zoom, our members on Zoom, does anyone have any questions for Ms. Henderson? Here in Carson City, Vice Chair Mosca.
Thank you so much, Chair, and thank you for this great presentation. I think making sure access is available to our public is so important. Can you just talk about any, outside of the box things you've seen from different states to get more public participation? I know, of course, every state, every legislature is different, but just would love to hear any examples of things that have worked and are unique.
Thank you for your question, Madam Vice Chair. Trying to think of an example off the top of my head on how to engage the public. It really varies, like you said, across states. Some chambers have very specific public-facing civic offices to do civic engagement. Those offices, like in Wyoming, for example, which has a pretty robust civic engagement portion of their staff, they reach out to engage the public just in teaching the legislative process, because as maybe you all are familiar with, sometimes the legislative process can get a little confusing for people not directly involved in it. And by increasing knowledge of the legislative process, that leads to an increase in public participation within the process because they know more about how to testify in front of committee, or that they even can. That's a pretty unique way that I've seen by leaning into the civic engagement. Washington also has a very significant civic engagement office within their nonpartisan staff office. I would say during the pandemic is when we saw maybe the most innovative in engagement tactics. North Dakota, for example, with their funding that they got from the federal government around COVID, they used that to actually build out their committee rooms to be to make it technologically possible for them to stream from their committee rooms. That included adding cameras, adding computers with Zoom capabilities and things like that, which was pretty innovative at the time. Those are the best examples I can think of right now, but I'm happy to reach out with other examples as they come up.
Thank you so much.
Thank you very much. And I guess just to follow up on the Vice Chair's question, it seems like so many young people now get their news through social media apps, sometimes even communicate through the messenger feature on the different apps as opposed to through phone or email. I just wonder, as you're looking for examples for Vice Chair Mosca, if there are any states that maybe have bridged that gap to notify folks who use social media as their primary news source and method of communication about things that are happening in the legislature and things that might interest them or that they might want to be engaged in. Because that's something that always worries me, that maybe folks aren't reading, the Review Journal or the Las Vegas Sun or the Reno Gazette, but they're getting their news from social media. Maybe they're not going to hear about a hearing on a bill that might be important to them, that maybe they'd want to log in and testify on or call in. And so if there are any states that have bridged that gap, to notify constituents through social media about things that might interest them, I'd really be interested in that too. And I appreciate the presentation and everything NCSL does to try to help us and help legislatures bridge that gap and modernize in a way so that our constituents can be engaged and involved. Members, any additional questions for Ms. Henderson? No, I'm not seeing any. Thank you so much for taking the time to present today, Ms. Henderson. With that, we will
Thank you,
now,
Mr. Chair.
Thank you. Really appreciate everything NCSL does to help us and legislatures around the country. With that, we will now move to agenda item 6. We are very fortunate to have another presentation from the National Conference of State Legislatures. We have Will Clark, Program Principal at NCSL Center for Legislative Strengthening. He will be presenting today on the use of artificial intelligence by state legislatures. Good morning, Mr. Clark. Thank you for joining us today.
Good morning, Chair and members of the committee. Thank you for having me today. Again, for the record, my name is Will Clark. I'm a program principal with NCSL. And one of my main topic areas at NCSL is, I apologize for that, is legislative IT. And as you can imagine, artificial intelligence has become a large part of our issue portfolio. A lot of members are asking questions, and we're trying to develop a lot of information and resources to help legislative staff as well as legislatures look at this issue, both in terms of regulation and in terms of internal usage by legislatures. So today I'm going to be talking specifically about use of AI by state legislatures. However, we do have a counterpart here at NCSL who works on issues related to regulation of AI, and there's an AI working group. So if you're interested in any of those resources, I'm happy to provide those after my presentation. Today, I'm going to go over primarily results from 3 surveys that we've conducted, asking legislative staff about their use of AI. Before I do that, I'm going to define AI briefly just to get on the same page about what we're talking about. And then I'll go over some development of AI usage policies across legislatures and in different states. And then I'll just give some examples from last year about usage of AI by legislators for developing speeches and drafting bills. So at a high level, the federal government in US code defines AI as a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations or decisions influencing real or virtual environments. Very broad overview of what AI is. If you kind of dig a little bit deeper, there are really two types of AI. We're merging into general AI, but we also have a narrow AI. And narrow AI focuses on specific tasks and is very prevalent in various applications that we use today. So for example, you have a chess simulation. You have specific rules, parameters for a program, and you interact with that program. And there's an artificial intelligence behind that that allows you to engage for a certain purpose. General AI refers to machines that have human-like intelligence, and they're across a wide range of tasks. And there are different subfields of AI. I'm just going to talk about a couple here that are probably more relevant to legislative work, but they all intersect and they can overlap. And these are by no means a comprehensive definition. But machine learning is one of the higher umbrellas of AI. It uses models and algorithms to give computers the ability to learn by analyzing data sets without being explicitly programmed. And how this could apply to a legislature, this machine learning is used for your current spam filters. So you can think about that. A spam filter learns what kind of emails come in, and then which emails should potentially be blocked. So it learns from all the emails that it gets, and then it's trained on a large data set, and then that helps protect users from spam or from viruses, things like that. Natural language processing, this is becoming kind of more recognized by the general public. It's used in ChatGPT, and so it's focused on giving computers the ability to understand and interpret and generate human language. So when you're inputting text into ChatGPT or Google Gemini or any kind of other chat program like that, a chat AI, the natural language processing is behind that, the ability of that program to understand your prompt. And then computer vision is another AI branch that gives machines the ability to interpret and understand visual information, such as images and videos. In a way, this might impact the work of legislative staff, is if you have maybe old documents, a photograph of a PDF, or a photograph of a document or a PDF from an older version, an AI program could look at that document and then translate it into a workable format. The last kind of defining characteristics of AI right now are traditional machine learning and then generative AI. So we're hearing a lot more about generative AI. Traditional machine learning is focused on analyzing data to find patterns and then to make predictions based on those patterns, whereas generative AI is focused on creating new data based on training data. So one way to think about this is traditional machine learning is like teaching a child how to recognize a dog. So you show them photos of dogs, you show them dogs in real life, and then the child recognizes that's a dog. Generative AI goes a step further. You do train it to recognize a dog, but then you also train it how to draw a picture of a dog. So that's kind of the next step, and that's why it's generative AI. Now, getting into our surveys, as I said, we've conducted 3 surveys recently of legislative staff, and I'll kind of go through each of them. The first one was a legislative survey of IT directors and chief information officers, and we asked them a lot of questions about cybersecurity and staffing. But we also asked them about AI. So this was the first time that we polled these members about their usage of AI. We heard back from members in 26 respondents from 23 states. And they told us that, and this was as of August 2023, that they were using AI already for cybersecurity and for transcription. So these tools are already being used by individuals. We also asked them if they were aware of legislators or non-IT staff that were using AI programs. And they told us that they are aware of transcription again, but also staff using them for informational mailers to develop summaries of information, and then for advanced searching. And typically, this was through ChatGPT or Bing. And then lastly, we asked them, what types of applications are they considering using? So this is kind of a look into the future. Also now, we've gotten some validation that certain legislatures are moving forward with these types of programs, but help desk support. So you can think of chatbots. If you've ever had to, call access an airport's website to get some information, or if flight's messed up, you might be push to a chat bot. And so some legislatures are looking at that for simple questions. Legislatures are also looking to use it for proofing, for document summarization. And then there's one state that is using it for translation, or it's moving forward with an option for translating both website content and then also through the hearings broadcasts. So you can make that available in different languages. And then probably most commonly, AI is present as a component in third-party applications. So you can think about, Microsoft product, you buy Microsoft Office for word processing, for PowerPoint, for Excel, but now AI is now a component in that, in Copilot. So AI is not why you bought Microsoft Suite, but it's part of it. So a lot of legislatures are recognizing they have programs with AI that's already baked into it. We also asked this group about the guidance that they're providing to staff in terms of using AI. So at that time, there was one legislature that had a policy for staff on usage of AI. But some other examples of what they were doing at the time was debriefing members and legislative staff on the risks of using AI and just answering questions. There was another legislative IT director who had an IT security update newsletter. They'd provide updates to their members on AI. And then probably the most common legislative IT directors were getting involved in an AI advisory councils. And a lot of times that included members of the executive branch along with members of the legislative branch to talk about usage of AI, but also be involved in the state's process for regulating AI. So that concludes that survey. The second survey was in response to a member request about use of AI for transcription specifically. And so to answer that question, or to help answer that question, we reached out to legislative clerks and secretaries, and we heard back from 32. And of those, 4 said that they are currently using applications with AI functions to transcribe hearings and committee proceedings. They said they were using YouTube, Slick, and Trent. And then there were 28 states that said they're not using AI transcription, and then 8 said they're not using it for any purpose. So there's kind of a shot in time. This was November of 2023. So you can see things are kind of moving over in time. And then more recently, last month, we sent a survey to many different types of legislative staff. So legislative IT staff, clerks, secretaries, librarians, auditors, researchers, fiscal, and caucus staff. We got back 58 responses from 31 different states. And of those, 8 said that they're currently using AI tools. Staff from 20 said that they're considering usage. And 8 said that they are aware of legislators or staff that were using these tools. And then 7 states said that their office was currently had a policy about usage of AI. So this gave us a kind of a new set of tools that are being used in legislatures. So you can see natural language processing. So things like ChatGPT and Bing, Amazon, they all use natural language processing. Again, that prompting the program to either create content for you, whether it be an image or whether it be a document summarization. One staffer said they were using Adobe Photoshop Beta, which is a tool that can be used to modify images. Then there's digital assistants. I touched on this earlier. Microsoft Copilot is an example of something that works in the background of another program. And then you have Lexis plus AI. And so that's for helping with legal research. And then a lot of staffers are using it for transcription and for editing. You have these 3 programs here that are used for different functions, but generally for transcription. And then for one example was using Claude to write to a 10th grade reading level. So lots of different ways to use these tools. And it looks like legislatures are just starting to open that box. We also asked the same question of this group if they were aware of other members or other legislative staff who were using these tools. And so these are the tools they came back with. ChatGPT, probably one of the most common ones that have been used by people. Grammarly, again, for spelling grammar checks. Copilot, an individual is using this for analytics. And then again, Lexis AI for legal research. And then aside from the tools that I've already mentioned, members or legislative staff said they were looking at possibly using these tools. So Westlaw, again, is legal research. And then Consensus is an AI search engine for research. Wdesk is an accounting and auditing and finance program. And then Gemini is Google's version of natural language processing. The last question we asked individuals for this survey was whether or not their office had a policy for AI. This is something that a lot of legislatures are struggling with in terms of providing guidance, how much to explicitly provide guidance versus allowing kind of staff or divisions within legislatures to develop their own policies. So we had staff from 7 states said that their office or their legislature had an official AI policy. Most often these were to prohibit use of AI tools. But there were other policies as well. Some policies encourage staff to just exercise good judgment and critical thinking when using AI tools. I'll show an example of one of those policies next. There was another legislature that requires consultation with their IT department before a staff can use an AI program, so it can go through a security design review. And then there was another state, and we're aware of other states that are starting to do this as well. But one state said that they had developed a study committee to make recommendations on creating an AI usage policy. So usage was prohibited in the division, but then a special group was established to start looking at a proper policy to be implemented. And this is an example of an AI usage policy, one of the first ones we became aware of. I won't go through it too much. I just wanted to provide an example. And essentially the policy is again, encouraging staff to use good judgment if they're aware of a data breach, to report that. So this is a very general policy, and I'll get into some kind of more advanced policies next. So probably some of the most comprehensive policies that we're aware of at a state level right now are with executive branches. So you've got the examples of Kansas, North Dakota, and Pennsylvania here. The Kansas and North Dakota AI policies were established by the IT security departments, whereas the policy in Pennsylvania was actually an executive order from the governor. They have like a lot of commonalities. They're generally talking about exploiting the benefits of AI while also protecting against the risks. And so you can go to these links here. They're in the presentation that I provided. And these are all just the purpose statements. But one interesting thing about these policies is in North Dakota, the legislative branch has adopted the executive branch's policy until they can examine possibly any specific protocols that need to go into their policy that make them different from the executive branch. But just providing an example of, there's a lot of information sharing going on right now. And so looking to other legislatures is very important, but also looking to your executive branch for experience is also helpful in this time. And then to round off my presentation, I'll just talk about some examples of legislators using AI. These all came in spring of last year. They were widely in the media, so you may have seen them. But these are 3 examples of AI being used for speech drafting. Oftentimes this was about AI. So you had one speech from a Texas representative about creating an advisory council to evaluate AI products and services. So that speech that they gave was developed by an AI. Another speech was about creation of U.S. Israeli AI Center. And then a U.S. Senator wrote a speech about open to hearing on AI. And that speech was interesting in that the member also had a voice modulation to sound like the member and played it for the committee. So, and then I have a couple examples of just bills that have been drafted using AI. In Massachusetts, there was a bill where the sponsor used it to write a bill that was regulating generative AI models. In another state, a member used Microsoft Bing to draft an amendment to a bill about money transmission and currency. And then after the success of that drafting, then they used it to draft another bill, an actual full bill about legalizing gambling on Alaskan ferries. And then in Congress, Congressman Ted Lieu wrote a bill to regulate AI using this following prompt. So you can see just how easy it can be. And this resolution, you can go to the link here and find it. So those are just some examples of AI, giving a basic overview of what's going on right now. We're still reaching out to legislatures and having conversations with members. But if you're also interested in just other information about legislative information technology, we have this page here, the top link, which goes to several other pages about different topics related to IT on the NCSL website. And then the survey that I first discussed, the Legislative IT Technology Survey, you can go to that link and find the results there for more comprehensive results. So that concludes my presentation. Again, I appreciate you having me here today, and I'm happy to answer any questions you may have.
Thank you very much. What an interesting and thought-provoking presentation, Mr. Clark. Members, any questions here in Carson City? Senator Daley.
Thank you, Mr. Chair, and I don't know, thank you for the presentation. My reaction is, are we out of our ever-loving minds? I just don't think there's anything good comes from this if you logically follow it out to some of the conclusions. And I look at the executive branch policies that you gave as examples where they say, oh, well, we'll just use the good part of AI and protect against the bad part. And I just think that type of control is not possible if these computers are, and AI is meant to be used or is going to evolve and get smarter and human intelligence except a lot faster. And I know this is beyond the legislative interaction part of it, but I just think that we couldn't control where we're at. If it gets smarter, becomes conscious of itself and exists, I'd be afraid to get the answer if I asked then that enlightened computer program is, how do you kill AI? And would it say, no, you can't kill me because I'm alive, right? It just, there's no end to this, and I think we're diving headlong into things, and I hope federally and at the state at least look into some of this stuff and do that. And then replacing people with some of the stuff on transcribing and that type of stuff. If it's smart and it's going to be predictive and it can't hear or actually understand what somebody's saying, then it's going to put words in your mouth. It seems to me it's going to add to some of these things. And I just think the applications are just too wide-reaching. And I know this isn't part of your presentation, but I just think it's dangerous. And I was just looking back earlier, remembering, when I was younger, but I'm going to read this statement and see if anyone recognizes it. It says, I'm putting myself on the fullest possible use, which is all I think that any conscious entity can ever hope to do. And that was the HAL 9000 in the Space Odyssey 2001, and HAL opened the pod bay doors. I'm sorry, Dave, I can't comply with that. When do we become the parasite? You ask AI a question like, how do we solve human hunger, or how do we do climate change? And the model would come back or could come back with, you could solve that by eliminating 2 billion people from the planet. And if they wanted to carry that out. And there's a million other ways that I think this just would get out of hand. And I know people are probably already doing these things because it's human nature. And human nature is consistent and predictable. And I just think it's more dangerous than it's worth. That's my comments. Thank you.
Thank you very much, Senator Daley. And I guess to follow up on that, some of the concerns I have is, let's say, you have a legislator in a state who wants a bill about regulating agriculture, and the drafting department uses some of these AIs like ChatGPT or Google Gemini to help write the bill. And I'm not sure I understand how they work completely, but what I've heard is that they pull from the internet and they pull language from statutes. And recently in Nevada, we've had to try to modernize our Nevada revised statutes and our Constitution because there's language in there that from many decades ago that is not language we'd use now. Recently, I think Senator Robin Titus proposed a constitutional amendment to remove some words from our state constitution that are offensive words now and words we would not use, and to describe people who have mental health issues. And I'm just wondering if, let's say, a legislator asked the drafting division to draft a bill about a certain issue, and that AI program like ChatGPT or Gemini pulls from old statutes and old constitutions. Is it possible that they're going to pull up some of these old terms and old ways of even writing that are not as inclusive as, we try to be now. So I just wonder, have any legislatures looked at that dangers of this technology and the way it pools and looks at all these data on the internet that's existing, but maybe not the way we want to draft legislation now. And then I'll go down to Sawyer Building. But Mr. Clark, I wonder if any of the legislatures you've looked at have looked at that.
Yeah, thank you, Chair. And I'd like to thank the other senator for their comments as well. Yeah, this is definitely something that legislative staff are starting to look at. I'd say that's one of the main reasons why we're focusing on policies for usage right now, because you bring up important points. There are a lot of risks in terms of sensitive data being released, being used for training AI programs, especially ones that are outside of the legislature's purview. That's why I'd say one way legislators and legislatures are looking to address this issue is by having a more localized program, especially for drafting. If you talk to drafters about AI, a lot of them have that same sort of consternation, same sort of hesitance to use AI tools right now, especially ChatGPT, Gemini, like you said. So I think that's a very valid concern, something that we're hearing from other legislatures. But a lot of the programs that are more specific for drafting that are used by drafters right now, some of those platforms are starting to look at usage of AI. And one of the things that they talk about is AI being a voluntary part of a package. And then if you do choose to use AI, potentially only having it use local data. So, open it up to the rest of the internet. And then another layer that you could tack on is to say legislature first, and then bring in results from the internet. But generally what we're seeing is a lot of these program developers are creating tools that are for a very specific purpose. And we are having these conversations with developers as well. Some of the really important guidelines that they're setting are making sure that there's always an oversight mechanism for humans. Humans should never be taken out of usage of AI. And so one of the things that they're looking at, these companies are looking at, is various controls and oversight mechanisms. So that, for example, if bias is identified in some sort of results, how do you get in there as a drafter in order to ensure that that's fixed, so that's taken out of the algorithm? So there are a lot of different controls that are being looked at, but those are all valid concerns, and those are something that legislatures are definitely considering right now.
Thank you, Mr. Clark. And I'm going to get to you, Senator Daly, in one sec, but you mentioned 7 states prohibit use of AI in the legislature. Do you happen to know what they are, or could you send us the info? I'd be interested to know which states prohibit use of AI.
I could definitely follow up with you after the conversation, and those results from the survey were confidential, so I'd have to just reach out to those states, because those weren't exactly, sometimes that was legislature-wide, and sometimes that was for a specific division, but I'd be happy to follow up with you afterwards.
Okay, and if it's confidential, then I understand if you can't share it, but thank you if you can. I think the committee would be interested. Senator Daly for a follow-up, then I'll head down to Las Vegas. Assemblywoman Miller, and then Assemblywoman Gonzalez, and if there's anybody else who has a question, either at the Sawyer Building or on Zoom, please raise your hand or jump in.
Thank you, Chair. My questions, and first of all, I do echo all the same sentiments as my colleagues up in Carson, specifically Senator Daly, sharing many of the same concerns for the same reasons, even when we're talking about displaced jobs for people. And so with this presentation, we've heard some of the abilities or why people would be using them. And again, I think I need to get on the record that after decades of spell check and grammar check is still incorrect. So it's really discouraging to hear that people would rely on that and Grammarly for things as important and life-altering as legislation and bills. But with that, what I would like to hear is not who's using parts of this, but what do we know about states that are actually trying to put in, that are proactively responding to their concerns or precautions or safeguards around the use of AI, and how, going back to the the real question in the room is, how do we take back control once AI or these computers or mechanisms decide that they're in control? What are the actual safeguards? So besides privacy concerns and all of these other things, it's like the mechanism used to regain that is that actual mechanism. So can you speak on that? What can be done, or what are states already looking at that should be done?
Thank you. Thank you, Chair, and thank you for that question. Yeah, I would say again, this is an iterative approach. I think some of the program developers that we've talked to in the legislative context are saying this should be iterative. This shouldn't be something that is just implemented overnight if the legislature is deciding to use these tools. In terms of the impact on the workforce, I think another way that people are looking at this is that AI should not replace workers. It should help augment the work of workers. So for drafting, that may not necessarily mean actually drafting a bill, but it might mean providing references to other legislation that has a similar theme, or it could be something such as replacing a word throughout a document. So there's a lot of different ways that maybe it's used to augment, but not necessarily replace human workforce. In terms of the controls, I think from a legislative context, again, so leaving out kind of ChatGPT and Gemini and some of those really large companies, from a legislative perspective, again, I think it comes down to setting parameters on the algorithms, working with the developers so that the people who are using those programs and also the IT departments that are implementing those programs understand how they work and then understand those oversight and those controls. So I'd say that one of the, in terms of the, your kind of final question, I think one of the most important parts is limiting the scope of an AI application. And that way, the controls are a bit simpler in terms of seeing what it's actually doing and then interacting with the tool itself. So instead of having it be a comprehensive tool, you'd have, think of it as just another software, just a more advanced software that's not necessarily thinking for itself, but that is supplementing another program, or it is a traditional service, but very much enhanced.
Thank you. Assemblyman Miller, any follow-up?
Yes, please, Chair. And I just all want us to take note of 5-10 years from now when we go back to look at this hearing, if we'll still feel the same about where we are with AI and technology. But my question, because it didn't specifically really answer if there are states or which states or what they're doing for those precautions. I understand you say that instead of making it comprehensive. But another question I think we should consider, if someone hasn't already, is in terms of liability. So when it comes to liability issues, and especially as legislators, we deal with a lot of not just private, but very sensitive, very emotional, like even just emails, for example. And I know you brought up in your presentation earlier about being able to screen through what's spam and what's emails. And again, very, very much emotional, personal, tragic stories and conversations that we hear from constituents. In a case where the technology would make a mistake, who would that liability fall on? Does it fall on the individuals who chose to use AI, or does it fall on the companies that are producing that technology?
Thank you for the question. And I just give the caveat that I'm not an attorney, so I can't provide a comprehensive answer for you. But we have had questions from IT departments about that very issue, and the way that we've approached it and the way that we've tried to find answers for legislative staff who have asked that question is really to look at the contracts. So I think it's going to become incredibly important to make sure that language related to AI is very fleshed out in contracts. And I think that's where legislatures are going to have the control and the protections for themselves if there is an incident involving these programs.
Okay, thank you so much for that. Thank you for your presentation, and thank you, Chair.
Thank you very much. And Assemblywoman Miller, I'm going to date myself here, but I'm going to throw in another quote from that great movie that Senator Daley quoted. And in that movie, the HAL 9000 computer tells the human that no HAL 9000 computer has ever made a mistake or distorted information. We are all, by any practical definition of the words, foolproof and incapable of error. So we need not worry, Assemblywoman Miller. Everything will be fine. Assemblywoman Gonzalez.
I feel so much better now, Chair. Thank you.
Thank you. Assemblywoman Gonzalez.
Hello, good morning. It's my first meeting back from maternity leave. This is awesome. I wish y'all were here though. I just wanted to, get on the record too. I have very much the same concerns as my colleagues. One of my questions or concerns when it comes to you talking about translation, for languages, Google can't even get that right? So I guess I have a concern about, how are we trying to make language access available accurately, I think is a concern for me. One of my questions is, what are the potential biases in AI algorithms? And how is that considered? And what are you doing to address that to prevent any discrimination? So, and also if there's any examples, have there been any examples where the algorithm showed that?
Great, thank you, Assemblywoman. That's a great question. I would say that issue starts to kind of get into another kind of how do legislatures regulate AI. And bias, I think, is first and foremost one of the most important issues, or one of the most prevalent types of bills that legislatures are looking at right now. We do have a website I can share after this hearing with a link, and it breaks down the different types of legislation that states are considering to prevent bias in algorithms. And as you mentioned, it is very common. It's very challenging, I think, to remove bias from these algorithms, because whatever data you put into it to train it, that's something that goes into the output. So one example I've heard recently was, if an AI is trained on a statement that says Ireland is the best country in the world, and that's used to train the program, not only will that come up as a potential answer for a search result, but it could also impact other answers that you may not think of. So that's a very trivial example, but you can imagine other ways that can be used, or that bias could impact real life decisions. And I don't know if I fully answered your question. I'm happy to answer any follow-up.
Yeah, thank you so much. It's definitely a concern, right? Another question that I have, and I think this is more so what I'm a teacher, and I'm in a PhD program, so more in the academic space, is how do you prevent plagiarism with using AI technology?
Thank you again, Assemblywoman, for the question. That's definitely something that has come up. I've been part of various webinars where people have brought up those examples. One way that I think I've heard that teachers have used to identify plagiarism is by actually you can feed some of those responses back into ChatGPT or some of those programs to see, or if you could put the prompt that you gave to the student into ChatGPT, and then if they come back with very similar language, I think over time you start to see, if you've ever played around with ChatGPT or any of the other ones, that the answers that they provide start to look very similar, or you can start to see patterns in the language. So I think that's one way that they're looking into this. But that is a very it's a question that is being asked, I think, across the country. It's something I don't think we have a definitive answer for right now.
Thank you so much.
Thank you. Any follow-up, Assemblywoman Gonzalez?
No, thank you, Chair.
Thank you. And Assemblyman Hibbets, any question? I didn't want to miss you if you have any.
Not at this time. Thank you, Chair.
Thank you. And members on Zoom? No, not seeing any questions. Senator Daley for a follow-up.
Thank you, Mr. Chair, again. And I don't know if it's exactly a question again either, but to follow up on my colleague from the South that asked the question regarding the liability and various things. And I think that's something that lawmakers will have to take a look at on how that works. I mean, you mentioned in your presentation that if you call the airline, you may be talking to a computer and various things. And I'm sure we've heard the story recently where a woman called up and said, "Hey, what's your cancellation or your refund policy for this particular issue or whatever?" And the airline didn't have one, but the robot that they were talking to went out and did whatever they do and made one up and told the person, "This is the policy and you can get a refund if this and that." And then when the person came back to the airlines and talked to a person, they said, "No such policy exists. We didn't tell you that." And I said, "Well, yeah, you did. Here you go," right? And I think the only way you fix that liability problem is you make whoever authorized the use of the computer that then gave you bad information responsible for that. And I was just thinking to myself out loud on this, if you applied this and you ask, because people ask the computer the question, how do you solve this? How do I do that? And if you put it in application to, say, the medical field and you're a hospital and you say, how do I maximize my profits? And I can imagine the computer coming back saying, well, don't take Medicare patients. They don't pay as much as someone else. How do I prioritize my resources and various things? It's going to start making calculations on where can I maximize my profit, on who's going to get the best rate of return, reimbursement on insurance. You know, this patient's better than that patient, and they extrapolate and say, well, this person has resources outside of this, so they can pay, and this one can't, and the computer has, you know, too much control. You'd have to make the CEO of the hospital responsible for that, but then if the CEO wanted to control the computer too much, he'd just kill 3 or 4 patients, and then you'd get a new CEO, right? I'm just saying this is very dangerous stuff, and I think the legislature's got to move forward and answer that liability question and make whoever made the decision to put it into place liable. That would maybe slow it down and people not being foolish. And the computers have never, ever made an error, Mr. Chairman. I know it's a fact, but you start asking it those questions, and it's going to start coming up with answers to answer the question. And it doesn't have any morals or any of that in consideration.
And to follow up, Mr. Clark, then and I don't know if this is confidential, I understand if you can't answer it, but in the legislatures you've surveyed where the drafting departments do use things like ChatGPT and Gemini to assist drafters, is there always a human who oversees the final bill or amendment before it goes to the committee or to the legislator?
You got my screen mixed up. Thank you for the question, Chair. To my knowledge, we're not aware of any drafters specifically that are using ChatGPT and Gemini. I have heard on various webinars internationally and here in the U.S. of drafters who are very reluctant to have drafts of drafts from those programs presented to them even to work on as a basis. So that's primarily what I have heard in terms of usage of it. However, in terms of, there are these other drafting programs that are, specific to drafting. They're, more controlled environments. I think that's from what we've heard from different companies, that's a really important component in these programs is the levels of review. So if you are using this tool, where is AI used in the process? So, you could limit AI to just being the first review of a bill and providing grammatic voice suggestions, sort of like a grammar spell check, but just an enhanced version of that. And in terms of just drafting a bill, we haven't heard of legislatures doing that just from the ground up. We've heard of it being used more as an enhancement. But I'd say again, I think that's where the AI policies come into importance again. We keep circling back to that. really important to define expectations of how these tools are used, including by drafters. I can imagine a system where every time an AI function is used, it could be logged in terms of the bill itself. So creating like segregated levels of control, and then ultimately perhaps you have the lead drafter responsible for if AI was used to augment that process or to be used to work on a bill, perhaps there's a process for reviewing those bills or reviewing a sample of them to ensure that by hand that they follow the protocol. So it's all speculation, but I've seen from talking to the programmers, again, it comes down to the oversight mechanisms that will need to be put in place by legislatures themselves to fit with their specific circumstances and conditions.
Okay, thank you very much. Thank you for that answer. Assemblywoman Gonzalez for a follow-up.
Thank you so much, Chair. Sorry, I just had a follow-up question in our conversations. One thing I'm interested in finding more about, or what does this look like in policy, is we've talked about like security and things like that, but who's getting all of this information, right? We recently found out Google was selling our data on the Safari. What is it called? The Safari, where it's like it's not supposed to track all your information, right? And then we came to find out that it was tracking your information. So I'm curious to know, with like these translations, like even like a conversation about national security, right? Like, how are we ensuring that this data isn't being sold?
Assemblywoman, I think again that's a very great question. That's something that legislators and legislative staff are talking about across the states. I'd say first and foremost, one of the most important ways to ensure that data is not being sold, or to ensure the best possible scenario that it's not being used inappropriately, is to have more limited programs with those contracts in an environment where that information isn't used, does not communicate externally outside the legislature. So having an AA program, and a lot of times, so for drafting, for example, you can choose what data would be used to train the program. So it would have a basic basic programming already when it comes in, and then it could just be trained on the legislature's statutes only. So the history of the statutes and the history of public bill drafts. And in that way, you would ensure that confidentiality wasn't being breached, because technically then the AI would be using publicly available data. And so there's that as one mechanism. The other mechanism would be, again, ensuring that staff are not putting confidential information into, for example, ChatGPT, where you're not certain, there's no guarantee that the information you put in there is going to stay locally. So again, coming back to that idea of policies, that's really important. And also, not saying that any states are doing this or that they should or should not, but also legislative IT departments can geo-block certain sites. So we've seen this with Twitter, or not Twitter, with TikTok, but it could be used in other realms as well. This is a whole legal issue, so again, I'm not advocating to do it or not, but that's just looking forward. You can implement policies, you can have programs that are more limited so that they're easier to control, or you can prohibit usage. So those are kind of three strategies, I would say, in response to your question.
Thank you so much for that answer. I was talking about incognito mode from Google. So how, we were told this service, like your data wouldn't be shared, right? So I think I heard more about the security aspect. I'm more concerned about like selling our data. So like, let's say I'm a legislator who is using these to like write policy or whatever have you, right? Am I now going to be targeted by like credit card company? Like, am I going to be targeted based on what I'm putting into that? And I just don't think there's enough information out there right now, because it is still so freshly new, but I definitely think that that's absolutely a concern. And then again, like whether you're putting something confidential in there or not, right? Like it's learning what you're putting in there, right? And so that, I think, again, with the data sharing, like, is a concern, but I definitely appreciate your answer, and I know that it's still in its, like, very infancy of this, but definitely a concern I wanted to put on there. And thank you so much, Chair.
Thank you very much. Thank you. And I think to echo Assemblywoman Gonzalez's concern about bias. I am worried that if it's used by a drafter and the program looks at historical statutes and amendments and constitutional language, that maybe something will be pulled up that might influence the drafting in a negative way based on what we're trying to accomplish now. So I'm a little worried about that. You mentioned two terms that I need defined. You mentioned geo-blocking and that the program uses an iterative process. Could you explain those?
Yeah, thank you, Chair. So in terms of an iterative process, when a lot of companies are talking about that, it could be implementing either instead of a whole suite of products, maybe that are in the background of all IT functions, you'd have one program. For example, you started using YouTube for transcription and see if that works for you, if it's accurate enough, or if it's a tool that you want to use. And then if perhaps if that doesn't work, you try a different tool, or within a specific tool. So if you have a drafting tool, an iterative approach would just be to use certain components of it. So you could take the most discrete usage of the program. It's only using the existing case law and previous bill drafts and statutes, and they only use it for example, as a grammar check, potentially for voice, just to ensure that it's matching the previous citations and the previous language that's used for that particular legislature. And within that, it could just be a comment on the side. So it wouldn't necessarily implement it. It would just give suggestions potentially for enhancing a bill. But the AI would never be able to actually manipulate the bill itself. It could just give suggestions. So that's kind of an idea of an iterative approach. From there, if the legislature is satisfied with that level, they could move up in terms of more and more functionality of an AI. And then for geo-blocking, it's just the way that IT departments can block certain websites, or geo-blocking itself is blocking internet traffic from a specific region. But you can also block specific websites also. So that would be the definition I would give.
Thank you very much. Thanks for defining those. Members, anybody else come up with any other questions they've got? We're so lucky to have Mr. Clark here on this issue. No, I think we kind of really used up your knowledge. Thank you so much, Mr. Clark. Really appreciate your presentation. And if you could send us that additional information and those links to those websites, I'd really appreciate that. I think the committee would benefit from that. Thank you so much.
You too. Thanks for having me.
We are now going to move on to agenda item number 7, overview of the interim structure of the Nevada Legislature. And we're very fortunate to have Ms. Prohl, our Senior Policy Analyst, GIS Specialist from the LCB Research Division, here to present on that issue. Thank you so much, Ms. Prohl.
Thank you, Chair. Good morning, members of the committee. For the record, my name is Haley Prohl. I'm a Senior Policy Analyst and GIS Specialist in the Research Division of the Legislative Council Bureau. Today, I'm going to be presenting on the interim structure of the Nevada Legislature, including an overview of the legislative and non-legislative committees, as well as changes proposed to the interim structure last session through Assembly Bill 243 that was vetoed by the governor. And as a reminder, as nonpartisan staff, I can neither advocate for nor against any policies that come before you. My presentation today is solely informational for the committee. As you are aware, outside of the 120-day sessions every odd year, the legislature is in an interim period. And during this time, interim committees meet to study policy issues in depth, receive reports, testimony, and public comment, and formulate recommendations for new legislation for the next legislature to consider. There are several legislative statutory interim committees that are governed by Chapter 218E of NRS. The Legislative Commission, consisting of 12 legislators, 6 from each house, supervises the Legislative Council Bureau, approves regulations, oversees all other interim committees, and takes other actions on behalf of the legislative branch when the full legislature is not in session. Its audit subcommittee receives final written reports of legislative audits conducted by the audit division of LCB. And its budget subcommittee considers fiscal issues that may require consideration by the legislature at the next regular session, such as the executive budget. The Legislative Commission also has a sunset subcommittee whose responsibilities include reviewing boards, commissions, and similar entities created by statute and determining whether each entity should be continued, modified, consolidated with another entity, or terminated, as well as recommending improvements to the entities that are to be continued, modified, or consolidated. The subcommittee must review at least 10 boards and commissions each interim and report its recommendations to the Legislative Commission. The Interim Finance Committee is composed of the members of the Senate Committee on Finance and the Assembly Committee on Ways and Means from the preceding session and meets to administer the contingency account, which was set up for emergency use by state agencies to supplement regular appropriations which fail to cover unforeseen expenses when the legislature is not in session. The IFC also reviews state agency requests to accept certain gifts and grants and modify legislatively approved budgets. The IFC also has a subcommittee on education accountability, which is due this interim. It was established by Assembly Bill 399 of the 2023 session. And this subcommittee is tasked with evaluating and making recommendations relating to accountability in Nevada's public education system in order to improve educational achievements and outcomes for students. The Interim Retirement and Benefits Committee reviews the operations of the Public Employees Retirement System, or PERS, and the Public Employees Benefits Program, or PEB, and makes recommendations to the PERS Board, the PEB Board, the Legislative Commission, and the Legislature. There are also 9 joint interim standing committees that meet during the interim to conduct in-depth studies of policy issues. These were newly established in 2021 by Assembly Bill 443, so this is only the second interim that they are in operation, and I will be going over these in more detail in a moment since they are newer. The Legislative Committee for the Review and Oversight of the Tahoe Regional Planning Agency and the Marlette Lake Water System was created in 2003 to review the budget, programs, activities, responsiveness, and accountability of the TRPA and the Marlette Lake Water System. And the committee also communicates with members of the California Legislature to achieve the goals set forth in the Tahoe Regional Planning Compact. And finally, the Legislative Committee on Senior Citizens, Veterans, and Adults with Special Needs was created in 2009 and reviews and makes recommendations on issues relating to those populations. There are also a few non-legislative interim committees that are overseen by the Legislative Commission or that report to and/or make recommendations to the legislature. The Nevada Youth Legislature consists of 21 high school students appointed by senators from each of the 21 state Senate districts who participate in meetings, trainings, and activities throughout a 2-year term to learn about representative government and participate in the legislative process. The NYL may request the drafting of 1 legislative measure per session and lobby for its passage. During the 2023 session, the NYL sponsored Senate Bill 80, which requires the development of education-related accommodation policies for students who sustain head injuries. This bill was passed and signed into law. The Board of Directors for Corporation for Public Benefit for Nevada Youth Legislature was created in 2011 to oversee the policies, practices, and finances of the NYL. The 7-member board includes legislators, representatives of the public, and when possible, former youth legislators. The Economic Forum is responsible for providing forecasts of the state's general fund revenues for each biennium budget period. The governor uses the forum's December forecast in each even-numbered year to prepare budget recommendations presented to the legislature the following January, and the legislature uses the forum's May forecast in each odd-numbered year to balance general fund appropriations with projected revenues. The Nevada Silver-Haired Legislative Forum, which consists of Nevada residents who are at least 60 years old, identifies and acts upon issues of importance to aging persons. There are 21 members nominated by state senators for appointment by the Legislative Commission. Members serve a 2-year term, after which senators can choose to nominate them for reappointment or choose to nominate someone new. The forum is not allocated any bill draft requests, but it may submit recommendations for legislative action to the Legislative Commission. So going back to the Joint Interim Standing Committees, as I mentioned, these were newly formed during the 2021-22 interim. Prior to their existence, there were interim legislative committees that were, they studied issues specific in nature, such as child welfare and juvenile justice, industrial programs, energy, special license plates. If the legislature wanted to study something outside the limited scope of these standing committees, it would create a separate interim study committee through legislation. These interim committees were repealed in 2021 by AB 443, except for the Tahoe Committee and the Committee on Senior Citizens, Veterans, and Adults with Special Needs. And the 9 joint interim standing committees replace these. They mirror the issue areas of the session standing committees. And additionally, the Legislative Committee on Public Lands that existed prior to 2021 became a subcommittee on the Joint Interim Standing Committee on Natural Resources. These committees consist of 8 members, 5 from the Assembly, 3 from the Senate, and 5 alternate members, all of who are appointed by the Legislative Commission. They are authorized to meet from November 1, following the adjournment of session, through August 31st of the following year. These committees are authorized to evaluate and review issues within the jurisdiction of their corresponding session standing committee, or they may be directed by legislation to study certain topics. Additionally, the 2021 bill provided 3 specific carve-outs for required issues of study. Health and Human Services must study issues relating to child welfare. Judiciary must study issues relating to juvenile justice. And Legislative Operations and Elections, this committee, may study issues relating to governmental purchasing. And those first 2 carve-outs were provided to ensure that those 2 issues continued to be studied after the repeal of the Legislative Committee on Child Welfare and Juvenile Justice. Each joint interim standing committee may approve up to 10 recommendations for bill draft requests for the next legislative session, with the exception of 3 committees that receive additional BDRs. So Health and Human Services gets an extra 5 for issues relating to child welfare. Judiciary gets an extra 5 for juvenile justice issues. And Natural Resources receives an additional 4 BDRs for issues relating to public lands based on the recommendations of the Public Lands Subcommittee. Last interim, after the legislature operated under this new structure with the Joint Interim Standing Committees for the first time, the Joint Interim Standing Committee on Legislative Operations and Elections identified some areas of improvement or just general changes to the interim structure and ultimately recommended a BDR, which became AB 243, that proposed the following 6 changes. So first, it made 2 clarifying changes that in the vacancy of a chair for a joint interim standing committee, the vice chair shall become acting chair until the chair is appointed. And it also required an alternate member attending in a member's place to be of the same political party. Third, the bill proposed to transfer duties to evaluate and review issues relating to governmental purchasing from the Joint Interim Standing Committee on Legislative Operations and Elections to the Interim Committee on Government Affairs, and to similarly require the Commission to study governmental purchasing to submit its biennial report to Government Affairs instead of Legislative Operations and Elections as well. Governmental purchasing is within the jurisdiction of the Assembly and Senate Committees on Government Affairs, and these committees are generally referred bills on this topic. So this change would just align the jurisdictions of the joint interim committees more closely with those of the standing committees during session. Fifth, the bill would have repealed the requirement for the Joint Interim Standing Committee on Health and Human Services to review regulations related to health care. This requirement, found in NRS 439B.225, does not provide for the formal approval of regulations, and this review is separate from the review and approval by the Legislative Commission. Before the Legislative Commission had the authority to approve regulations, the Legislative Committee on Healthcare would review regulations related to healthcare, and then when that committee was repealed in 2021, that duty was transferred to the Joint Interim Standing on Health and Human Services. However, since these regulations are now approved by the Legislative Commission, it's a duplicative effort for the HHS committee to also review these regulations, and additionally, no other joint interim standing committee has a requirement to review regulations. And number 6, the bill as introduced would have revised the submission date for applications to serve on the Nevada State Teacher Recruitment and Retention Advisory Task Force. It would have changed the date from January 15th of an even-numbered year to December 1 of an odd-numbered year. This would give the Joint Interim Standing Committee on Education the time it needs to appoint these members to the task force. Right now, that turnaround time is about 2 weeks between receiving applications and making appointments. So this change would give the committee 2 months in total to make appointments. Assembly Bill 243 went through several revisions during the 2023 session, and ultimately 10 additional changes to the interim structure were amended into the final version of the bill. First, it would have authorized the Joint Interim Standing Committees to meet as early as September 1 after the adjournment of a regular session, and similarly require members to be appointed by August 31st following such adjournment. So this would provide for a longer meeting period so that committees could have more options for meeting dates and more time in between meetings. It would also ensure that the Legislative Commission meets in a timely manner to establish the interim committees for each interim. Second, the bill would have made the subset subcommittee independent of the Legislative Commission, rename it as the Sunset Committee of the Legislature, allocate 5 BDRs to the committee, and align all other aspects of membership, organization, and operations with those of the joint interim standing committees. This would give the Sunset Subcommittee more flexibility to fulfill its duties and streamline the administration of the committee with other interim committees. Currently, the Sunset Subcommittee must conclude its work by June 30th of each even-numbered year, and it does not receive any of its own BDRs. It must rely on the Legislative Commission to take up any of its recommendations. Additionally, the subcommittee has 6 voting members, no alternates, and 3 non-voting members of the public. So this change would also change the membership of the subcommittee in line with those of the joint interim standing committees. Third, it would have also aligned the membership and organization operations of the Tahoe Committee and the Legislative Committee on Senior Citizens, Veterans, and Adults with Special Needs with those of the Joint Interim Standing Committees, and this would mainly affect membership and member appointment procedures. The final enrolled bill of AB 243 would have eliminated the Subcommittee on Public Lands and transferred its powers and duties to the Joint Interim Standing Committee on Natural Resources, which would be renamed to the Joint Interim Standing Committee on Natural Resources and Public Lands. It would have also required that committee to hold at least 3 meetings outside of Clark County, Washoe County, and Carson City. The Subcommittee on Public Lands assumed the duties of the previously existing Legislative Committee on Public Lands. However, the Joint Interim Standing Committee on Natural Resources may already studied this issue. Additionally, the subcommittee is not allocated any BDRs, and it must report back to the full Interim Natural Resources Committee. So this change would streamline the operations of the Interim Natural Resources Committee while retaining the customary practice of the previous Legislative Committee on Public Lands to meet in other parts of the state, and additionally allow the full committee to partake in those roadshow meetings. Number 5, the bill would have changed the Joint Interim Standing Committee requirements for approving recommended legislation from a vote in favor by the majority of senators on the committee and the majority of assembly members on the committee to a vote in favor by at least 5 members of the committee. Number 6, the bill would have transferred certain duties that are fiscal in nature from the Joint Interim Standing Committee on the Judiciary to the Interim Finance Committee. With the repeal of the Committee on Industrial Programs in 2021, its duties were transferred to the Joint Interim Standing Committee on the Judiciary. However, some of these duties are possibly better suited for the IFC to handle. These include reviewing state-sponsored industry programs to determine if they are operating profitably, recommending whether a prison industry program that incurs a net loss over 2 consecutive years should be continued or terminated, and reviewing proposals submitted by the Department of Corrections for expenditures of the prison industry's capital projects fund. Number 7, the bill would have required the Governor's Office of Finance, the Office of the Attorney General, and law enforcement agencies to submit certain reports to the Joint Interim Standing Committee on the Judiciary. The committee identified that it would be helpful to receive certain information relating to practices of the State Board of Parole Commissioners, criminal sentences imposed by the state or in the state, use of force data, and projections on the annual number of persons in DOC facilities. The bill would have also changed the submission date of the report submitted to the Joint Interim Standing Committee on Education relating to instruction on genocides from October 1 to July 1 of each even-numbered year. Since the Joint Interim Standing Committees must complete their work by August 31st of each even year, the current deadline for this report may require the Joint Interim Standing Committee on Education to request an additional meeting to meet beyond August 31st to consider this report. The bill would have also eliminated the requirement for hospitals to submit certain staffing committee reports to the Joint Interim Standing Committee on Health and Human Services. This change was recommended by the Nevada Hospital Association. The NHA had identified the submission of these reports as a duplicative effort to ensure compliance with the mandates of staffing committee laws. To ensure compliance, the NHA developed an audit tool and worked together with hospitals to review their policies and procedures and make recommended changes when appropriate. In addition, the Bureau of Healthcare Quality and Compliance annually audits the hospitals for compliance with staffing committee laws and provides them with a DHHS star rating that must be posted in all points of entry and exit. And finally, the bill would have clarified that legislators and legislative staff are not prohibited from undertaking or attending legislative committee investigative meetings, events, or trips under the Nevada Lobbying Disclosure and Regulation Act. Currently, under this law, legislators and legislative staff may not accept anything of value from lobbyists except under certain circumstances. One such circumstance is to attend educational or informational meetings. So this proposed change would clarify that meetings, events, or trips in connection with a legislative committee are also exempt from the gift prohibitions under the Act. So Assembly Bill 243 was vetoed by the governor, so all these 16 provisions I just went over were not implemented into law, but they are just outlined for the committee's information today, in case they would still like to consider any of these. And finally, I've included some links to some research division publications that provide additional information about the interim structure. All of these can be found on the link on the slide, including bulletins or summary reports for previous interim committees that detail their activities and recommendations. And with that, Chair, that concludes my presentation. I'd be happy to answer any questions.
Thank you very much. Before I go to members, I just had a couple of quick questions. Going to the non-legislative interim committee slide, I wanted to verify Nevada Youth Legislature has one bill draft request, but Nevada Silver-Haired Legislative Forum does not have any bill draft requests currently under statute. They need to ask Legislative Commission for a bill draft. Is that correct?
Haley Prohl, LCB, that is correct.
Okay, that must have changed recently because I seem to recall that they did have a bill draft, unless I was misunderstanding. I thought it was a dedicated bill draft for Silver-Haired Legislative Forum. I didn't realize that they needed to request one from Legislative Commission, but I'll have to go back and try to look and see if that changed. Members, any questions? Vice Chair Mosca.
Thank you so much, Chair, and thank you for this detailed information. I thought it was a very helpful overview. My question was just more clarification question. So things like members being able to be on Zoom, or what happens when someone misses and the person who's able to come in their place, is that all under the Legislative Commission?
Haley Prohl, LCB, for the record. I believe that would be up to chamber rule. I would want to defer to legal if possible, if they know the answer on the top of their head.
Certainly. Would that be okay to go to legal counsel right now? Thank you. Please go ahead.
Thank you, Madam Chair. Asher Killian, Legislative Counsel. Yeah, that would be at the chair's discretion.
Thank you, Mr. Killian. Vice Chair Mosca, any follow-up?
Thank you.
Thank you. Members, any additional questions here in Carson City? Down at the Sawyer Building, any members with any questions? On Zoom. And I don't want to miss anybody, so if I don't see your hand, please jump in. Okay, I don't see any additional questions. Thank you so much, Ms. Prohl. And now we are very fortunate to have Ms. Prohl also presenting agenda item number 8, presentation on the issue of legislative modernization. Thank you very much for presenting on this issue. And again, before you start, I want to echo, I believe, some of the comments we had earlier from one of the representatives, Ms. Henderson from NCSL, when she commented about how the Nevada Legislature was one of the early legislatures to allow teleconferencing, and just what a tremendous job LCB's done, and our current staff, our past Director Erdos and Director Malkowicz, and making sure we had that teleconference down to Southern Nevada, and then teleconferences to Elko, and then when COVID hit, being able to log in on Zoom. I think it's made the legislature so much more accessible. And when I hear comments from NCSL about how our legislature was one of the leaders at the forefront at having these technological assists that make it more accessible for our constituents to participate, it really just makes me, value everything that LCB's done through the years to bridge that gap around the state, Southern Nevada, Elko, and all parts now that folks can participate without, even if they can't make it up to Carson City or to the Sawyer Building. So, Ms. Prohl, please go ahead with your presentation on legislative modernization.
Thank you, Chair. Again, for the record, my name is Haley Prohl, Senior Policy Analyst and GIS Specialist with the Research Division of the Legislative Counsel Bureau. This next presentation is about legislative modernization, or the enhancement of the legislature's capacity to perform its role in the policymaking process. Legislative modernization generally refers to 4 things. Legislative sessions: how often is the legislature meeting and creating policy? Is the desire to have a professional legislature that meets most of the year, or is the desire to have a citizen legislature where members have other full-time jobs? Legislator salary: are legislators compensated fairly for their work? Does the salary rate discourage certain people from running for office? Legislative staff: how much staff support is there both during session and the interim to help legislators do their jobs? And technology and infrastructure: what new innovations can be implemented to increase the legislature's ability to create policy and serve constituents? So I'll be going over how Nevada compares to other states in these regards, and some approaches that other states have taken to modernize the legislature. And this presentation is not necessarily to prescribe a certain structure or advocate for one over another. It's just kind of to give a lay of the land and show how Nevada compares. So a little background on legislative sessions in Nevada. As originally drafted, the Nevada Constitution specified when the first 3 sessions of the Nevada legislature would occur, and provided that after the first 2 sessions, the legislature would meet biennially in odd years. In 1958, voters approved a constitutional amendment providing for annual sessions, but then 2 years later approved an initiative returning to biennial sessions. So the Nevada legislature has held biennial sessions since 1867, except for the additional regular session held in 1960. As you're likely aware, sessions are limited to 120 calendar days. However, this wasn't always the case. As originally drafted, the Constitution limited sessions to 60 days. Though there was a period of time from 1909 to 1957 when sessions actually extended beyond 60 days, as the legislature would, quote, cover the clock and proceed as if the 60th day consisted of an unlimited number of hours. So this led to a constitutional amendment in 1958 to remove the limit on session lengths and allow sessions to continue for as long as necessary. However, it also limited the number of days a legislator could receive a salary to 60 days. From 1989 to 1997, sessions were no less than 161 calendar days, with the longest occurring in 1995 and 1997 at 169 days. Following those 2 169-day sessions, voters approved another constitutional amendment in 1998 to limit sessions to 120 days and provide that sessions would now start on the first Monday in February of an odd year. Nevada is only one of 4 states that has biennial legislative sessions. The other 3 are Montana, North Dakota, and Texas. The last state that switched from biennial to annual sessions was Oregon in 2011. 11 states do not impose limits, either through the state constitution, statute, or chamber rule, on the length of regular sessions. California and Kansas are a bit unique in that the legislature may meet for as long as it wants in odd years, but is limited in even years. Of these states with annual sessions, the legislatures either meet for equal lengths each year or hold a longer session in 1 year of the biennium. Some states also limit the scope of the second session in the biennium, usually to fiscal matters only for setting an annual budget. 16 states have equal length sessions every year. It appears that out of these states, Alabama meets for the shortest, which is 30 legislative days. And Colorado is one of the states with the longest annual sessions that are prescribed by law. Of course, the states with no limit on annual session lengths may meet for longer. 19 states have different length sessions depending on whether it's an odd or even year. Out of these states, Wyoming imposes some of the shortest limits of 40 legislative days in odd years and 20 legislative days in even years. And there are 2 states that have unique session lengths throughout the biennium. So Mississippi's legislative sessions are usually 90 calendar days long unless it is the year after a gubernatorial election, in which case they will meet for 125 calendar days. And Minnesota imposes a limit on the cumulative session length over a biennium, but it does not impose annual limits. I've also included some information on how many days state legislatures are actually in session per biennium, since session limits may not provide an accurate picture of just how often the legislature meets. For example, states with shorter Regular sessions may have more frequent special sessions, and it's also hard to gauge out of the states that don't set any limit how long they are actually in session for. So this table includes a 10-year average of the total days state legislatures were in session per biennium, and this includes regular and special sessions. And this data is from a 2014 study done by some Harvard professors regarding legislative professionalization in each state. And the table also includes population totals and ranks. So you can see how there is somewhat of a correlation between state population and how frequently the legislature is in session. So for example, the Wyoming legislature meets the least frequently, but it also has the smallest state population. Nevada, at the time of this study, ranked 38th in average total days in session out of the 50 states, but also ranked around there for population in 2010 as well. It had the 35th highest population. Legislator compensation is another component of legislative modernization and a factor in determining whether a state legislature is considered full-time or part-time. Full-time legislatures typically pay a living wage to legislators as if it is their full-time job. So the salary rate for Nevada legislators is $130 a day. This is set in statute, and it has not been changed since 1989, although there was a bill in 2005, Assembly Bill 462, that allows this rate to increase by an amount equal to the percentage increase that state employees receive. So the amount for the 2023 legislative session was around $160 a day. However, the Nevada Constitution limits the number of days that legislators can receive this salary. It limits it to 60 days of a regular session and up to 20 days of a special session. Legislators also receive per diem allowance equal to the federal rate for Carson City for each legislative day, and they receive travel allowances and other allowances for expenses related to legislative business. So how does Nevada's legislator compensation structure compare to other states? Well, it's not the lowest paying, but it certainly does not qualify Nevada as a full-time legislature. Many states have not provided salary increases to legislators for decades, or in New Hampshire's case, for over a century. Texas, which is another state that has biennial legislative sessions, pays legislators an annual salary of $7,200, which, though that has not seen an increase since 1976, is still more than Nevada legislators make over the course of a biennium. New Mexico legislators are the only state legislators that do not receive a salary. However, they do receive per diem, so they are higher paid than those in New Hampshire. 10 states pay legislators an annual salary considered to be a living wage when considering session length and district size, or the number of constituents that each legislator is serving. So, for example, California and New York's legislatures are meeting for most of the year, and they are representing very large districts, and these legislators tend to be paid really well. Alaska state legislators are also paid a wage of what is considered a living wage of $50,000 per year, considering that they are only in session for 90 calendar days each year, and the state's population is about 750,000 people. And then 8 states do not provide per diem to legislators, though 3 of those states, which are bolded on the slide, already provide a living wage to legislators. And per diem is meant to cover the cost of lodging and meals while performing government duties. Legislative staff support is one way to increase legislative capacity. When legislators have access to professional staff, they have the greater ability to check executive agencies and government programs, build expertise on policy, and conduct constituent services vital to the communities that they represent. So the map on this slide is of a 2021 NCSL legislative staff census and shows which states have larger staff size in the darker green colors and which do not employ as many permanent and session staff in lighter green colors. Of course, the appropriate staff size may depend on how many legislators each state has. So it's also helpful to consider the average number of staff per legislator. And in this regard, Nevada actually ranks pretty highly among other states. So in 2015, Nevada ranked 6th overall for number of total staff per legislator and 13th overall for permanent staff per legislator. The state that hires the most staff is California. They have a legislature that operates essentially year-round. And so they have the same number of permanent staff per legislator as they do total staff. And North Dakota ranks at the bottom with essentially 1 permanent staff member per 4 legislators. It's helpful to have a sense of all the different state approaches to legislative sessions and legislator compensation, but a more useful comparison may be between states with a similar population size to that of Nevada. Arguably, larger states are going to have different needs and function very differently than smaller states. So this table includes a comparison of the 2 states right above Nevada in population, Utah and Iowa, and the 2 states right below, Arkansas and Mississippi. And Nevada is the only state of the 5 with biennial sessions, but interestingly enough, is in session on average the same amount as Arkansas and more frequently than Utah throughout a single biennium. Nevada legislators are also the lowest paid of the group. Even though Utah legislators make slightly less than Nevada legislators per session, they have annual sessions, so they receive that amount per year. I've also included a comparison of states that have similar population demographics to Nevada. Population size might not tell the whole story because states' populations also differ in characteristics, which may play a role in determining how the legislature should most efficiently be structured. So this table includes the 4 states that are most similar to Nevada according to the Daily Kos State Similarity Index. This index was actually used in a study done in New Mexico regarding legislative modernization. The index goes from 0 to 100, with values closer to 0 representing greater similarity to the state in question. And to find the values, the index considers Census Bureau variables, including age, race, median income, educational attainment, workforce, industries, home ownership rates and median home value, and more. So there's really no state that Nevada is super similar to, as the lowest index score for states compared to Nevada is 29. So I guess this just confirms that our state is unique. Out of these states, Nevada's legislature meets the least frequently per biennium and is still the lowest in terms of compensation. And also another interesting fact about this index is that the similarity index score of the United States when compared to Nevada is 32. So Nevada is actually most similar to the entire nation than it is to all other states besides Arizona and Texas. So I just thought that was interesting. I want to briefly touch on additional legislative modernization policies, but I won't spend a lot of time on this, especially since we've already heard from NCSL today. I will mention, and as the chair mentioned, Nevada was really at the forefront of video conferencing technology. Nevada and Alaska were some of the first states to use this since they have large population centers that are far from the capital city. Virtual participation, especially the changes that have been implemented since the pandemic, not only provide more participation options to legislators, but also members of the public, which increases the effectiveness of the legislature and increases its capacity for creating policy. Family-friendly legislative building infrastructure, such as changing tables, pumping rooms, and on-site childcare, can make legislative buildings more accessible to caregivers and families, whether they are legislators or members of the public. So this can ultimately encourage more people to participate in the legislative process and even run for office. Another newer component of legislative modernization is paid family and medical leave for legislators. So far, Colorado is the only state to implement this. Colorado has 120-day annual sessions and pays legislators an annual salary of about $44,000. So they have arguably already taken care of the pay problem and were able to focus on this additional compensation and benefit policy for legislators. And finally, what are some approaches that states have taken to modernize the legislature? In terms of legislative session length, many state legislatures study this issue and gather input to determine what changes to the current structure, if any, should be made. In 2005, Oregon created a public commission on the Oregon legislature that included 30 members of the public representing all sectors of Oregon's population and regions, and the commission studied all aspects of the legislature, including annual sessions and compensation. Oregon also did something unique where it tested its capabilities for holding annual sessions before it moved to that structure. So the Oregon legislature called itself into special sessions in 2008 and 2010 to address budget issues and to show that they could manage a short session and accomplish what they set out to do. In terms of legislator compensation, there are challenges to increasing legislator pay. Often pay is set through law, which requires the legislature to vote on its own pay raises. This is what NCSL calls the pay problem, or the idea that there are inherent political risks to raising one's own salary. So to get around the pay problem, some states create compensation commissions to study and recommend, or sometimes directly set legislator pay. And the responsibilities and powers of these commissions vary across states. So in California, the commission directly sets the salary. In Connecticut, the commission offers recommendations, but the General Assembly still votes on whether to enact them. In West Virginia, the legislature is actually required to vote to approve the commission's recommendations. Similarly, in Alaska and Washington, state legislatures retain the right to vote on commission recommendations, or they can choose not to, and after 90 days, the commission recommendation has the force of law. And finally, in Texas, the Ethics Commission can give salary recommendations, but changes to legislative salary must be approved by ballot initiative. Other states tie pay to external factors like rate scales or pay indices, which allows for automatic increases without legislation. For example, Massachusetts ties legislator pay to median household income. Pennsylvania legislators receive cost of living increases tied to the Consumer Price Index, and legislators in Nevada and Florida receive salary increases when state employees do. So there are potential benefits and disadvantages to each compensation setting method. For example, even with the method to tie salaries to external factors, the raises could still create negative perceptions. For example, if the pay was tied to median pay in a year before a recession or tight budget, and then the next year those legislators still received those raises. So that's all I have for legislative modernization. I'd be happy to answer questions at this time. Thank you, Chair.
Thank you very much, Ms. Prohl, for that excellent presentation. Members, are there any questions for Ms. Prohl? Down at the Sawyer Building, I don't see any here in Carson City. Down at the Sawyer Building, anyone with any questions? I don't see any hands, but if I miss anybody, don't hesitate to jump in. For our members on Zoom? Well, I'm not seeing any questions. Thank you so much for this. Oh, Senator Daley.
I just was going to get a clarification on the per diem. Is per legislative day. How's that defined? I mean, we have 120 days, and theoretically, all of those can be legislative days, or is it just limited to the 5 days during the week on the per diem?
Haley Pearl, LCB. And are you referring to just Nevada or generally what other states?
No, for Nevada, I think it's on slide or page 6.
So legislators, yes, they can receive a per diem allowance for each day during a regular or special session. And legislators also receive per diem during the interim for each day of attendance at a conference, training session, meeting, or seminar.
So is it for all 120 days or just the days during the week?
Sorry, I was just conferring with legal. I
She's
believe
gonna
it's
phone her friend.
I believe it's each day that the legislature is conducting business.
Thank you, Mr. Chair.
Mr. Killian, please go ahead.
Asher Killian, Legislative Council. Yes, it's basically any day that legislative business is occurring. So it's not just the days of session, but also potentially days before session where legislator training is occurring, any of those days where legislative activity is occurring.
Thank you. And I just want to compliment the LCB staff, Director Anthony, former Director Erdos, former Director Malkovich. The item about the family-friendly legislative building with the changing tables, pumping rooms, and on-site childcare. I know during the 2015 session, my wife and kids were up, and Assemblyman Garner's kids were up, and their childcare was kind of running around through the building and commandeering elevators, taking over, and it was great for them. I know it was tough on some of everybody else here in the building, so it's so great that there's going to be these options now for legislators with kids. And then I think of another prior session when a friend of mine from the Boyd School of Law was up here on an externship with former Senator Sagerblum, and his family, his kids came up, and it was always a challenge because they sometimes would come into the building and try to stay entertained. But it's great that these options for legislators and staff and maybe interns and externs who have kids will make this building so much more family friendly. So that's fantastic, and just have to take my hat off to LCB for that, for getting that accomplished. And any additional questions? I don't want to miss anybody. Anyone down south on Zoom? All right, well, thank you. Thank you so much, Ms. Pearl, for this excellent and informative presentation. With that, we are now at agenda item number 9, public comment. And just remind everyone who wants to make public comment, please state your name for the record and limit your comments to 2 minutes. Staff will time each speaker during public comment to ensure that everyone has an equal and fair opportunity to speak. If you're calling in to provide public comment, please dial 888-475-4499. Again, that phone number is 888-475-4499. The voice prompt will prompt you to enter a meeting ID, and this is the meeting ID you need to enter, 845-8785-4029. Then you press the pound sign. Again, that meeting ID is 845-8785-4029. Then you would press the pound key if you're calling in to make public comment. So before we go to the phone lines, I don't see anyone in Carson City who wishes to make public comment. No, down at the Sawyer Building in Las Vegas. I'm not sure if anyone's there or not who wishes to make public comment. I'm not seeing anyone. So broadcasting, if we can go to the phone lines, if there's anyone who wishes to make public comment, please state your name for the record, and we are limiting it to 2 minutes per speaker.
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now. Chair, the public line is open and working, but there are no callers choosing to participate at this time.
Thank you, broadcasting. And if we could just wait for another minute or so, just in case someone's trying to call in, give them the opportunity to participate. Thank you, members, for your indulgence. Thank you, members, for your indulgence. Broadcasting, I just wanted to check and see if anyone else had called in wishing to make public comment on the phone lines.
Chair, the public line is open and working, but no other callers have joined.
Great. Thank you, broadcasting. Thank you, Ms. Prohl, for your presentation. The presenters from NCSL, our two registrars, our Deputy Secretary of State for Elections. Thank you, members, for your excellent questions. And I think we've learned a lot and come up with some good ideas possibly for changes to things here in Nevada. So thank you so much. With that, we are adjourned.